We live, Ryan?
We are ready to go.
All right, thank you. Good evening, everybody. Sorry we're about 10 minutes late. We had a few things we had to get taken care of. First, I had to get me a sweatshirt. You guys know it's getting fall is my favorite time of year. It's getting a little chilly outside, so I went and got me a sweatshirt because we got all the windows open. So it's nice to be that time of year. Let me turn my phone off. Sorry about that. So everywhere, I mean, where we're at right now, all people want to talk about is the no cash bond provisions of the Safety Act. And I've talked to a bunch of judges, I've talked to state's attorneys, and one of the things they want me to talk about with you guys is to explain and give an understanding of why cash bond, again, they use the word cash bail. That's actually technically inaccurate, but cash bond, I'll get to that in a second, that talk about the important role that that plays, and if you take that out of the equation, how that's not going to help anything. And so, every judge or every state's attorney, pretty much that you talk to, will agree on that the propaganda that Pritzker and the like are using to try to eliminate it, really it's all false propaganda for the most part. And it doesn't mean there's not an occasion where something happens and somebody is in jail that absolutely shouldn't be there, except for they can't post some money. I tell you what, tell JB Pritzker, here's what I want you to do. Remember when JB Pritzker got on television a week ago and said, the lady that just goes and steals the diapers is held in jail for 6 months, waiting trial. Here's what I'll tell you. You go get JB Pritzker and you'll find him, or you send him an email, or you call him and you tell him to give you one real situation of where a lady who took some diapers for her children sat in jail for 6 months waiting trial. Tell him to give you a real case, a real court case, because that case would be public record someplace. Tell him to show it to you. It doesn't exist. And if J.B. Pritzker personally will give that example since he's been, let's call it since he's been governor, of a lady sitting in jail for 6 months because she just took some diapers, I'll give $2,500 to any charity that J.B. Pritzker wants me to give it to, because it doesn't happen. That's absolute fallacy. Took some diapers, petty theft, sat in jail for 6 months because they couldn't post a little bit of cash bond. Prove it, JB, that it doesn't exist and you're just blowing smoke to try to scare people. So let's talk about the cash bond provision and what role that it plays. The Constitution, Article 1, Section 9, deals with bail, okay? Because when someone is accused of a crime, a citizen of our state accused of a crime, you all have to remember that in our system of justice, they're innocent until proven guilty. Merely because they've been charged with the crime, they're not guilty. Now, sadly, human nature, we as human beings have an inclination when someone's charged with a crime to have already determined that they're guilty. So, I mean, and you guys, if you're going to be honest with yourself, because I read a lot of the stuff that I see on social media, I just don't comment sometimes. I hear people saying that, oh, well, they've been charged with a crime. They shouldn't sit in jail until they go to trial. Why would we let them out before they go to trial? Because they're innocent until proven guilty. And so the community in general has a tendency and has had a tendency over our, hundreds of years to not treat those accused of a crime kindly. And so our Constitution recognizes that we have to protect everybody's rights, including those who have been accused of a crime. There is a balance to that where you also have society and the community as a whole that needs to be protected, and even to make sure that those accused of crimes, don't allegedly cause, I want to make sure I say this right, allegedly do anything else when they're out. So we don't want them committing more crimes when they're out for the crime that they're have been arrested for. So there's a balance. Society needs to be protected, but they have rights. And so our Constitution, Article 9 or Article 1, Section 9, says that all persons, everybody, shall be bailable by sufficient surety. Shall be bailable by sufficient surety. Here it is. See where Ryan's got it up right there? Very first sentence. All persons shall be bailable by sufficient surety. What does it mean to be bailable? What it means to be bailable is that you have the right to be out, to be released from jail pending your trial. To be bailable has nothing to do with money directly. To be bailable just means that I'm going to be released from jail pending trial. So all persons have a right to be bailable by sufficient surety. Sufficient surety means either potentially money or promises that you're going to do what the court wants you to do while you're out waiting for trial. So everyone has a right to be bailable by sufficient surety, which means they make promises or potentially pledge money that they're going to actually do what the court needs them to do while they're out. Make sense? Now, there are some exceptions in the Constitution for people that don't have a right to be bailed out, which means the court can keep them while they're waiting for trial. There's some absolute categories. And to be really simple, it means in present day time, if you've been accused of a crime for which probation is not an option, first degree murder, attempted first degree murder, armed robbery, if you've committed those types of crimes allegedly, the court can hold you and not even offer you bail. There's a few other small exceptions I'll give you one that you'll understand. Even if you've not been accused of one of those crimes for which bail can be denied, and it's otherwise a bailable offense, but if the court thinks that if they let you out, you're going to go mess with witnesses, or you're going to mess with jurors, or you're just going to go finish the crime that you've alleged to have committed, if the judge gets those kind of inclinations, they can still hold you without any bail, even though the offense that you've allegedly committed is bailable. The court has that discretion. Does that make sense? Okay. So let's say someone in the current present system is accused of domestic battery. We have sadly a lot of domestic battery in our state and our nation. You get accused of domestic battery and you get arrested. That is a bailable offense, which means the Constitution says that you have a right to be out on bail pending your trial by sufficient surety. So when you go and see the judge after you've been arrested, the judge you'll have a hearing about your bail. And there's all kinds of conditions that the judge is going to want you to follow once you get out. One of the big ones is that you have to return to court at your court hearings, right? That's a big one. Another one is you don't break any other laws while you're out. The domestic battery will have a condition that you don't go around that person, whoever that person might be. You don't do any, drugs, maybe any alcohol. There's conditions that the judge is going to require you to have to follow. So then, once you get all these conditions, the judge has to make a decision on each case. Can I let this person out on their own recognizance, which means I am satisfied merely because they promised to me, the court, to follow these conditions? And if the judge is satisfied that that's sufficient, they will be let out and they don't have to post any cash bond. Make sense so far? Pretty straightforward. But let's say the judge is not convinced that that person can comply with those conditions for whatever reason. Maybe the judge has facts in front of him that this person may not show up to court, or maybe the judge has some facts that this person may not quit calling or stopping by the house of the person that, they allegedly abused. Whatever the judge has, the judge may say, your promise alone is not enough for me. So I'm going to make you post, I'm just make up the number, $1,000 cash bond. And that cash bond is an incentive for you, the citizen, to comply with these conditions that I didn't think your promise alone was sufficient. So you're going to put up this bond. And that bond is, again, additional surety for the court to be satisfied that you'll comply with the conditions. The conditions are still the same. Those never change. But the bond, the cash bond, is merely because the judge wants additional assurances that you're going to do what he wants you to do while you're out on bail. Now, that number that I use for $1,000, it might be $250. It might be $5,000. It depends upon a lot of factors. This person's criminal history, the severity of the circumstances of the case, etc. So that bond number fluctuates based upon the judge being satisfied that that number is at a level that assures they comply with the conditions. That's the purpose of the cash bond, okay? And keep in mind the domestic battery charge that we talked about. The judge has to offer them under the Constitution, has to offer them some type of bail, has to let them out on something, unless one of those nuances that I was talking to you about existed. If the judge was convinced if he lets you out, you're never coming back to court, ever, and he's satisfied that that's the case, he doesn't have to offer it to you. If he thinks you're going to leave and go and continue to abuse the person, okay, then he may hold you. But absent that, merely because of the domestic battery charge alone, without anything else, the judge has to let you out on bail. Okay, that makes sense? So that's the system now. Now, let's say you post $1,000 because the judge wants that additional bond that you're not going to follow his pretrial release conditions. And let's say he lets you go and you're out and you don't come to court on the day you're supposed to come. What happens on that day? The judge issues a warrant for your arrest. He's going to ask that a warrant be issued, or the state's going to ask, the judge will issue it. And now there's a warrant for your arrest for failure to appear. And what the state's attorney is going to do is ask for a bond forfeiture, which says that bond, that $1,000 that you posted, they're going to take it from you because you gave them that money and said you would do what you were supposed to do. So they're going to take your money. There's going to be a warrant for your arrest. Now, eventually you get arrested again. They're going to bring you back, put you in jail, take you back in front of the judge. And he's going to not be happy that you didn't show up. He may very well release you on another bond, but you know what? It's not going to be $1,000 this time. It might be $5,000 or $2,500. He's going to raise the number to try to incentivize you to actually listen to what he said. And the system uses that money for that purpose, okay? That's what it does. Now, that's the system as it exists today. You understand why the cash component is a part of it. Because again, if the judge doesn't believe the promises alone are sufficient, he's going to add the money as a motivator for you to listen to him. Because human condition, all of us is, money makes us listen, right? If they're going to take your money, you're more inclined to listen than if you just gave them a little promise. So that's the current system in a very high arching 30,000 foot. Okay. Now let's talk about what they're trying to do now. What are they trying to do? What the end? And I'm not going to talk about the constitutionality of it because I think this whole bail modification process that's in this Safety Act I think it's all unconstitutional. But let's set that aside. Let's talk about the policy of what they're really trying to do with this Safety Act, because I want you guys to see the problem with the policy itself. Leave the constitutionality out of it just for this conversation. So the policy, so the governor, again, he said that we don't want the lady sitting in jail for 6 months that took some baby diapers. I've already told you that's not happening. It's not even possible. What about somebody who commits the domestic battery? Let's go back to our domestic battery example, okay? And let's say that someone commits domestic battery now with this new law in January. What's going to happen? They're going to get arrested, take them to jail, and then they're going to go in front of a judge. Okay? Because domestic battery is actually listed in the 7 categories of crimes that the legislature is trying to say you can detain someone. So they're going to go in front of the judge on this domestic battery charge. The judge is going to have a hearing. At that hearing, remember all those promises that I told you that the judge is going to want you to make to him before he lets you out? All of those promises exist. They're still the same. Those are not going to change. Next year, after the Safety Act would potentially go into effect. And now the promises are still the same. Show up to court when you're supposed to. Don't break any laws. Don't do any drugs or any alcohol probably. And don't go around the person that you allegedly domestically abused. Still the promises, right? Or still the conditions. Now you're going to be, with the Safety Act, you got the promise that we won't violate any of this stuff. That's all you got's the promise, because they're trying to take the cash bond provisions that I talked to you about out of the equation. So here you got all these promises that the judge wants you to make. And let's say that the judge is not convinced that this person is going to live up to those promises. Before, the judge would say, well, I'm not so sure your word's good enough, so I'm going to throw $1,000 on our example, remember? They're trying to take that away from the judge. Trying. Again, I think there's some constitutional issues. Set it aside. We're talking policy now. They're going to take the $1,000 away, and judge can't do it. What's the judge's option if he doesn't think this person's going to comply? And he can't make them pay the $1,000. What's the judge going to do? Maybe he's going to detain them until trial. Now, there's a huge constitutional issue with that. We're not going to get into that. I'm talking just, again, I'm going to repeat myself over. We're just talking policy. You're going to detain them till trial? Someone who has allegedly committed domestic battery, they're going to detain them for 3 months because the judge doesn't think that the promises will apply? Are you kidding me? Are you kidding me? That's the scenario. Let's throw another example in there. Let's throw in robbery. Okay, robbery. Now, robbery's not even in the categories. So remember, you've seen the meme. So in these 7 categories, the robbery person, they might hold, but he's never going in front of the judge under this law. It's stupid, right? It's stupid. Let's then take another one. Kidnapping. Not in the categories. Doesn't go in front of the judge. Just going to let him go. Go back to our domestic battery one now, because again, it's in the 7 categories, went in front of the judge. Do you think the judge is going to let him go just on the promise? Or is the judge going to hold him until the trial? Which one do you think the judge will do? Because judges are going to be in that situation if we don't change this. Now, if the judge holds them without offering any cash bond to make sure they apply, will listen to the promises, the judge holds them until trial, he's probably violating that person's constitutional rights. I'm going to go ahead and give you that. The judge would be violating their constitutional rights without offering them that bail with the bond money. So what's the judge likely going to do? Probably just let them go. So keep letting even more people out. And even without even the money incentive to comply with the pretrial conditions. Let's talk about one of the categories that's actually in there. There's a lot of weapons violations in the 7 categories, okay? Unlawful discharge of a firearm goes in front of the judge. The judge, under the current law, would say, yeah, you're probably going to have to post $2,500, so I know you're actually going to listen to me, and you're going to show up to court. You're going to not shoot any more guns off in the air. That's obviously one of the things a judge would want, right? Etc. Now, in January, the judge is going to be back to his 2 choices. Hold them merely on the or let them go merely on the promise that he'll comply with these conditions, or hold him until trial, likely in violation of the constitutional rights. So what's going to end up happening probably is the judges, because they don't like to violate people's constitutional rights, would be more inclined to just let people go. Even for ones they can potentially detain, they're going to just let them walk. I'm going to leave you with this before I answer a few questions. Governor Pritzker always likes to say, he uses the lady with the diapers. He always likes to say, well, the guy with money shouldn't be able to bond out. And so this is about equity. And if the poor guy can't bond out, the rich guy shouldn't bond out. That's one of his favorites, right? That's one of his favorites. So let's just run through that scenario again with the new law. Let's say they commit a serious felony, but they have to be offered some type of bail under the Constitution. And so you got the poor guy and you got the rich guy. And let's say they go through and the judge has all his conditions that he wants on them, right? And let's say they're both exactly the same type of person. And the judge has the same concerns about either one of them actually complying with what he wants them to comply with. The rich guy and the poor guy are the same exact situation, both as the charge they've been charged with and their personality and who they are. They're identical. And the scenario is now, let's say he would set their bond at 10 grand. And the judge would say 10 for both of you. The rich guy says, okay, I can put the money up and I'm going to be bailed out. But when he puts that money up, he's assuring the judge with money that I'm going to comply with your conditions, because if I don't comply with your conditions, I lose my 10 grand. Okay. And the judge felt that the 10,000 was sufficient to get him to comply. Now the poor guy doesn't have the $10,000, but the judge still is convinced that the 10,000 is necessary to make sure that he complies with the conditions, because the judge is trying to protect the community. So the poor guy doesn't have the 10,000. He sits in jail. What's the alternative? Let him go just on a promise? Judge didn't like that idea, right? So let's come to the Safety Act now. So in this scenario, one guy bails out, the other guy can't bail out. But what's the option to the guy that can't bail out? We haven't talked about that yet. So let's go to the Safety Act. You bring both of these guys in front of the judge. The judge has got two choices now for both of them. Detain them until trial, or let them out just on their promise. What's the judge going to do? If he detains them both until trial, the poor guy is still sitting in jail, right? If he detains them both, the poor guy didn't get out. If the judge lets them both go, then you've got two alleged criminals on the street instead of one. That's a potential opportunity. But if the crime is severe enough, the judge could just hold them again, probably in violation of their constitutional rights, but he could hold them both until trial. So my point to you is these scenarios that the governor's talking about, they're not even going to be resolved with the Safety Act. The Safety Act is going to cause more issues. Because the reality of it is, you guys, the cash bond component of our criminal justice system is necessary in order to get people to comply with the conditions that the court needs. Because if you commit a serious enough crime, the judge doesn't want you out on pretrial unless he knows you're going to do what he needs you to do, without breaking any more laws, showing up to court, etc. And sadly, it takes money sometimes to incentivize people to not break those rules. Because the promise alone, probably not enough or it wouldn't be good enough for either one of them. So, I mean, that's the cluster that the governor's trying to create with this thing. He's trying to say the cash bond provision, the bail component is bad, bad, bad. It's not bad. It gets used the way it's supposed to be used. And, his scenario of about, well, the rich guy gets to walk and the poor guy doesn't. Have him again show you the examples, like real examples, where the rich guy and the poor guy that committed the exact same crime with the exact same criminal history, one walks and the other one doesn't. Again, it sounds good when he says it, but have him show it to you in real life. It's not there. So, taking this cash, I want to leave you with this, taking the cash component out of the bond as it relates to bail is not going to solve anything. It's going to make it worse. It's either going to result in a whole lot of people getting out of jail just based on their promise, letting them all out of jail just based on their promise, with no additional security that they're going to do what they're supposed to do. Just give their word, or you hold them in violation of their rights until trial. That's the two extreme scenarios that the governor and Kwame Raoul have created. Okay. Let me see here. Let me see if there's anything in here real quick, guys. See anything, Eric? Or Eric? Or Ryan, sorry, I was thinking about Eric. I don't see anything. I mean, somebody's mentioning there, you guys know about January 1st, right? I mean, because all of the state's attorneys and the sheriffs are trying to figure out who in their jails right now would qualify to be released on just their promise to return. And there's what, 4, 5, 6,000 people that on January 1st would be released out of the jails. So, you guys know about that. Yeah, I agree with, it's kind of what Marina says here. If you want to know what the Safety Act's going to do statewide, just look at Chicago, because Chicago has been utilizing the provisions in the Safety Act for quite a few years now. So, everything that's in the Safety Act has been going on in Cook County with Kim Foxx for quite some time. And you see how that's working out for them in Cook County, right? So take what they're living up there and put it in all of our other communities across the state. And that's what you're going to have, because people are people and their behaviors are always going to be similar everywhere that we're at in the state and the nation. So when you make the law be the same across the state that they have in Cook County, you're going to get a version of Cook County. I mean, there's no way around that. So we can get rid of the Safety Act provisions of this cash bailable offenses stuff. There's been 4 lawsuits filed by state's attorneys. I think 4. The 4th one might have got filed. 2 of them Democrats that I know of, arguing some of the Constitution, not all of them, but some of the constitutional issues on this thing. And Kwame Raoul even got on TV the other day after he sat silent for 2 years going, yeah, I've got some concerns about this cash portion of the Safety Act. No kidding. So I don't think he'll do anything. He's certainly not going to sue the governor or the General Assembly for any of these constitutional issues on the Safety Act. But if I'm the Attorney General, I'll sue him right first week in office as soon as I can get somebody to draft it, because it needs to go away. And again, the lady, I'm gonna leave you with this: the lady that's getting the diapers, if she took some diapers, she's not sitting in jail, you guys. She's just not, because the jail can't afford to put somebody in jail for something like that and take care of them. And it doesn't make any sense economically. So it's not happening. So, but again, my offer is still good. You go find JB, you tell him to bring you that real life example of the single mom with no criminal record who took some diapers and sat in jail for 6 months. I'll give $2,500 any charity he wants. You guys have a good night. Okay.